Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Today is a pre-recorded episode. So as you all know by now, sometimes schedules do not align for a Friday live session, but we always try to bring you something new to listen to during your Friday afternoon. So pre-recording is the second best option. Be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. On today's episode, we have Monte Tynes and Courtney Wilson with us out of Mississippi to talk about order of proof and witness prep. Now, Monte's been on the show before, so you may remember him, and we are excited to have him back. And then we welcome Courtney as well as a newer guest with us today. This episode comes on the heels of a verdict that these two obtained in July. At least that's I think I'm right that it was in July-ish, of $1 million. You guys can correct me if any of that information is wrong, but Papa Don requested that we have them on the show as he described the verdict as one on a tough case in a tough venue. So we'll put Monte and Courtney's contact information in the description below, so you can contact them directly with any questions you have after listening to this pre-recorded episode, since obviously you can't ask questions as this is occurring, but write them down and send them to these folks if you have any questions. Now, Monte and Courtney, tell us how you used order of proof and witness prep to get this outstanding result.
Yeah, well, I do have to make a slight correction. It was a $931,875 verdict. It wasn't quite $1 million. So I would love to take credit for or partial credit for $1 million verdict, but we did not obtain $1 million verdict on this case.
All right. Well, honor is definitely in your favor, but I think we can call it $1 million-ish, right? Close to, like about. Can we say about $1 million?
About close to. Yeah, in this case, we represented a wonderful, wonderful lady named Mozilla Brown. I have actually, almost my entire career, I've either represented Mozilla Brown or somebody from her family or her church. That was a direct result of Mozilla Brown sending those people to the Tynes law firm. So I've known Mozilla since 2006. When I originally represented her on a workers' comp claim for a back injury she sustained working as a registered nurse at Memorial Hospital in Gulfport, Mississippi. She ended up having a lower lumbar surgery in 2007 as a result of that back. I think she had a microdiscectomy. But she really is a wonderful person, very religious, great mother, has a wonderful son named Aaron, who I've known, for over a decade as well. And I'm just ecstatic that we were able to achieve her some justice for what she's going to have to live with for the rest of her life, because she did sustain, contrary to the defendant's position, she did sustain a severe injury to her lower back, aggravation of her pre-existing condition, and a cervical injury as well. Courtney actually worked most of the case up. So if Courtney, if you want to tell kind of how you did that, what we did in the workup before trial.
Sure. So Miss Mozilla is your sort of classic eggshell plaintiff. She was very vulnerable. And in working the case up, we sort of saw that it was going to be really important to get our treating doctor on board and have him strong on what exactly it meant to be vulnerable and susceptible to an injury, and able to explain that to a jury. So we started early on talking to who ended up being her back surgeon. Dr. Wilson is a neurosurgeon down here in Mississippi, and he's pretty great, like in my estimation, as of late.
He's a treater willing to testify. He is already like 90% better than everybody else. So
yeah. And unlike, some doctors that you talk to, he was actually willing to like meet with me before we did the deposition. And like, he wanted to know what, what he was going to be pushed on, what were going to be the defenses. So I had the opportunity to kind of go through all that with him, point out specific things in the medical records, show him our, big boards with the MRIs on them. And Monte and I have some models. So we've got a model spine, and we have a bulging disc model that it's not in here. If you squeeze it, the disc bulges out.
Oh, nice.
So I brought all that to him. He got to play with it all beforehand. So he's very excited about using it for the trial deposition, which I think was great, actually, because he was sort of like excited to go on stage when we did the deposition. So Dr. Wolfson was great in that regard. But the other side of that is sort of the people in Miss Mozella's life who were able to help us flesh out this substantial injury. And as defense counsel is wont to do, they characterized her injuries as minor. It's a low impact car wreck, no visible property damage. She went to the hospital. She had a sprained strain that healed up in 6 weeks. Wow, good to go. But in truth, this wreck changed her life entirely. And what we did was we had the people in her life come and talk about that. So she was volunteering at the time of the wreck as a senior companion volunteer. So what that meant was she was older at the time of the wreck. She was 60 something, but she was volunteering to help even older individuals do light housework. Come and sit with them and talk to them. She also drove them around, maybe to pick up some groceries or run errands. So that's actually what she was doing when the wreck happened. She had an older gentleman in the car, and they were rear-ended. Now, unfortunately, the older gentleman had passed away by the time we got to trial, so he was not available. But we were able to get the woman who was running the senior companion program. So we talked to her, and she was able to testify that Miss Mozella had been this great volunteer. She really had a heart for it. She really wanted to help people. She loved being of service, all this stuff. And then she was able to talk about the kinds of things Mozella did, the housework, the transportation, the blah, blah, blah. And then she was able to say that after this wreck, Mozella couldn't do this volunteer work anymore. She really wanted to, she just couldn't do it because her back hurt. And that ultimately she had to give up the volunteer opportunity. And she described the conversation they had about that and how Mozella was upset during that conversation that she didn't want to stop volunteering, but she just couldn't do it anymore. And, Ms. McGee, that was her name, she was this completely sort of independent third-party person. She didn't have a dog in the fight, and she had no reason, to make anything up or to, I guess, lean on the plaintiff's damages.
That's what we hear, right? If it's a family member or a friend or even sometimes a coworker, juries are like, they're trying to help their person out. But if you're, if you own a volunteer company or if you coordinate volunteer work, that's something really independent.
So, and to lay a little groundwork in this case, so what was going on is as Courtney said, Miss Brown was volunteering this day, taking this older gentleman to get a haircut. He lived on one side of town. The barber shop was kind of closer to downtown Ocean Springs, Mississippi. And they, instead of getting on the highway, they were driving on a little 2-lane road called Government Street in Ocean Springs. and it's 2 lane with a little turn, and part of it has a little turn lane in the middle, and it runs parallel with the railroad track. And where this wreck happened is right next to the high school football stadium, Greyhound Stadium, where I personally played football and soccer, and to great accolades in
Yeah, excellent.
1996 to 98.
That might have been part of why you got such a great verdict. They were like, "Oh my gosh, we know Monte."
And it was just up the street from an elementary school called Pecan Park, where I actually went to elementary school at. And so they were doing some work on the road, and she got stopped in traffic. Or the construction zone, the workers stopped her. So she'd been stopped there for a while when she was rear-ended by the defendant. The funny thing, this orthopedic surgeon the defense hired with a fellowship in spine surgery also had an undergraduate and a master's degree in mechanical and biomechanical engineering. So he estimated the wreck, I think it was, I don't know, was it under 5 miles an hour, Courtney?
Yeah, that sounds right.
Under 5 miles an hour, and there was no property damage to either vehicle at all. And when they got in the wreck, our client, Ms. Brown, got out and the defendant got out, and they conversed, and nobody called the police. Our client said she didn't call the police because she didn't have her cell phone. And the defendant went to the elderly gentleman and asked him if he was all right. And he said, "Yeah, I'm fine. How's my car?" And she said, "Oh, it's fine. Can I leave?" And she then left. Our client then takes the guy to go get his haircut, and then returns him home, and then goes to the police and reports the wreck to the police, 3-4 hours later, 2 or 3 hours later, that afternoon. This happened about lunch-ish. And she didn't actually go to the doctor, to the hospital, until the next day. And so that's the groundwork of what happened in this, like the actual what happened on the day of the wreck.
That's a tough one. That is a tough one.
And I didn't mean to interrupt, Courtney, but I wanted to give context of exactly what was going on in this wreck, and some of the hurdles that we had to overcome in this trial, and the work up to the trial, so you could see kind of how important some of this stuff is and was to the case.
Yeah.
Because like I said, we had no damage to either car.
That's incredible. And everybody who's listening who has ever had a case like this, what do they call them, missed cases in the insurance industry or whatever, those are the particularly difficult cases to take. So I applaud you guys for taking it in the first place. I know that you had a relationship with Ms. Brown prior, but oof, that's tough. Like, that's really, really tough. And add to that the fact that she's a little bit older and has this pre-existing condition. Okay, so let's then go back to, I know we had the volunteer lady, and then we had some friends and family. What was their input, Courtney, on kind of how her life had changed?
So we had Miss Mozella's best friend. Her name was Miss Janie Lincoln. She came, and I talked to Miss Janie several times before the trial, and she's your typical before and after witness, okay? So the first time you call them, they're like, I don't know you, I'm gonna talk to you. And so I told her, call, I'm sorry about the train. I told her, okay, well, call Mozella, let her tell you that I'm, really her attorney and I'm not trying to trick you. So we do that. And then she calls me back. She's, afraid now. Like, she doesn't want to say the wrong thing. She doesn't know how she can help. She wasn't there at the wreck. She doesn't think she has anything to say. So I explained to her, I don't need you to know about the wreck. I need you to tell me about Mozella. So let's talk about how she was. before the wreck, leading up to the wreck, and then if that changed, how it changed. So over the course of like several phone calls, Miss Janie finally warmed up enough to tell me about Mozella. And it was funny because she had my cell phone number, and I thought we had established what she was going to testify to the week before the trial was supposed to start. But the weekend before the trial was supposed to start, she probably called me 6 times. And like, particularly on Sunday morning, she called. And I remember this very specifically because I was trying to make an omelet and I ended up burning the omelet. But she called Sunday morning and she was, I don't know what happened, but she was suddenly ready to like be emotionally vulnerable and tell me how she really felt about what happened. Maybe she had been to church.
I was wondering that too.
I don't know. But she told me that they were supposed to go on this retirement trip. She and her best friend had this big plan to go on a tour, like a cruise to Alaska. Am I remembering that right, Monte?
Yeah.
So they're going to go on this big, in my mind, like Stella Got a Groove Back cruise.
Mm-hmm.
And that was the plan. And they had booked it out. Mozella was excited about it. Janie was excited about it, but they had to delay it because Janie was also, I think, a nurse, and she was supposed to retire, but they didn't have somebody to replace her. So she pushed it by like 6 months, and, the trip got pushed, and then Mozella got into the wreck, and they never went on their like do it big trip. So she was still so upset about this. And so that was a big part of her testimony. Like, they didn't get to go do this thing.
Yeah.
But Janie talked a lot about how she felt like she had lost her best friend. So Mozella used to like cook dinner for Janie, have her over. They would do drinks. They would go out to the movies together. They would do window shopping. They would go, do all these little best friend things together. And then after the wreck, that stopped. Mozella couldn't do that stuff anymore. She couldn't go walk and window shop. She didn't want to go out to the movie theater. She wasn't able to stand and cook anymore. It changed completely. And bless her heart, Miss Janie got very upset on the stand. And, she got sort of emotionally overcome when she was trying to explain how she lost like this extremely important part of her life because of the wreck.
And how do you think that played with the jury? Did they kind of warm to that emotional display, or, obviously they didn't hate her or they would have punished you, but what did you think?
I hope so. Monte, can you answer that better? Because I directed her, which means the way our courtroom set up means the jury was back here and I couldn't see them.
Okay. All right. Yeah. What do you think?
What was the question?
What do you think? Do you think the jury, Courtney said that Miss Jeannie got kind of emotional on the stand, and I've had mixed results with that. If my witnesses get emotional, sometimes the jury is like, oh man, I feel you. And other times they're like, that's inappropriate and I don't trust you because you're faking it or milking it. What did you think the jury felt in this case?
Yeah, so I've been like on both sides of that too. Yeah, we actually tried a birth injury case in this exact courtroom where the girl was paralyzed from the chest down. And in that jury, when anybody teared up in that case, you could see the scowl on their face. And we ended up losing that case. We got a defense verdict on that case. So yeah, I know what you're talking about. And some of the way we picked this jury was a little odd in that they picked a grand jury the day before. And we usually, when we start civil trials in Jackson County, we start on Monday. and it's the whole panel or the whole venire. We don't get a list of who's going to be actually on our panel and stuff like that until they bring that panel into the courtroom right after they do the general qualifications. Well, they did the general qualifications the day before, picked a grand jury out of them. So we had our panel, like our actual panel that we were going to do voir dire from the day before, and we only had 24. So we didn't have a big panel where we had to pick 14 out of the 24 to have a jury. So it created this weird relationship where you didn't want to strike many people for cause because you knew if you did that and everybody uses all their preemptories, then you bust a panel and it's a mistrial. We got to come back another day. And we felt pretty good with the panel that we got. Like there were some people that we were kind of on the fence about, but we actually studied that pretty hard the night before. And we had people on this panel from the very get-go when we started voir dire that just seemed to care about people in general. The responses to any question was kind-hearted. So it was these people weren't the people that just turned off. It didn't seem like to me. Now, in Mississippi, you're not supposed to contact jurors after the fact. In federal court, it's strictly prohibited. In state court, it's a little mushy, but because of some of the post-trial motions in this, we did some research on it, and we found that there's actually, unless you get permission from the court to do an investigation that's not supervised by the court, you're not supposed to contact the jurors. So we haven't contacted them to see how they felt about certain pieces of evidence and that kind of stuff, because we want to respect what the law is in Mississippi.
Sure.
But they all seem to react positively to every witness and arguments as well.
Yeah.
So
really?
they all had positive body language. Some of them shook their heads, when during certain parts of the testimony and stuff like that. And I think this witness was no different than the rest of them. They all seemed to respond positively to it. Even the two people that kind of got tripped up.
Mm-hmm. Okay. Interesting.
That was a long-winded answer. Sorry about that.
Yeah, no, that's a great answer. I mean, it really brings up a few different things, and we'll circle back, Courtney, to finish up with was it Janie or Miss Jeannie? Jeannie or Janie?
Janie.
Janie, I'm sorry. But yeah, I mean, at some point there are several things in a trial that we don't have a whole lot of control over, right? We try to control and prepare the best we can, and there's certain things. One of those is who shows up that morning or who ends up being in the veneer and who ends up being in the box. And sometimes you just get a bunch of hostile people and you can't get rid of them all. And sometimes you get a nicer, kind of warmer group. And and it's really a testament to the fact that, that those personalities really can help in cases like this. So, people who use positive body language and even in situations where, we don't have a lot of control over who's there, these are things to be looking for, folks who are listening, as, these key words that Monte is talking about, that are kind of giving kind answers, giving caring answers, because the words that come out of someone's mouth don't always match the way they decide a case. But if the way they're answering is a kind and thoughtful and respectful way, and they're giving good body language and are happy, those are some things that we can all take into our trials from what Monte just shared. So okay, cool. So then Janie getting emotional on the stand, how did the rest of her testimony go?
Well, I mean, none of our before and afters were real long, so that was pretty much the sum total of it.
Okay, so tell us about that. I know in the colleges we talk about how before and after witnesses need to have like specific stories and be kind of, I guess, short and sweet. How did you work on that with them, and how did you make sure you presented it that way during trial? Because I feel like sometimes I plan a 30-minute witness, and for whatever reason, it just goes and goes.
Well, I'll tell you, the idea was for none of these witnesses to be anywhere near 30 minutes.
Yeah.
We were trying to keep things moving. So This is what I do with all my before and afters. Like I was telling you, it's usually kind of a long process over the course of a couple of weeks where I talk to them several times. It takes them some time to warm up. You got to let them start to develop a relationship with you before they'll actually talk to you. And there's got to be a level of trust before they'll tell you anything about their friends or loved ones. So over the course of that process, you will get to a point where they will be willing to tell you something. And then once they do get there, it's hard to like shut those floodgates back, right?
Yeah.
So, there's sort of an art, I think, to it, to just listening to them, letting them tell you these stories about their friend, and then you being able to pick out, okay, what is going to help? What's going to connect with another person? Like, what is moving, So I'm actually looking at all these notes that I have from talking to these people. Like, I've got pages and pages of notes from where I talked to each individual witness, and they told me, a story about one thing or another. And over the course of the several weeks that we did this, I was able to kind of narrow down, so that each of my witnesses had a really clear idea. Like, okay, Miss Janie, we're going to talk about this retirement trip. And then we're going to talk about going to the movies. And we're going to talk about how she used to cook dinner for you. And we're going to talk about, these sort of, if not, I'm sorry, I don't know what my computer just did.
Oh, did it like turn off or something? Can you still see us? We see it.
This is interesting. So, but basically, what she did is she got in a quick little vignettes like this, like that with from each witness, and we got lots and lots and lots of them from everybody that we did, and we were trying to pick and choose which small quick vignette you told a specific story about how she was like before this wreck. Even though she had that pre-existing back surgery, she had some years of pain management treatment, and matched it with a vignette that told a different story after the wreck. So it became, it's a very tedious process to go through, and Courtney did a phenomenal job of talking to these people over and over and over again, getting them to trust her, so they could give these type of stories and these quick vignettes about what Miss Brown's life was like before before this wreck happened. So we had Miss Cindy and her friend. Those are really the only two before and after witnesses that weren't Miss Brown or her son Aaron. And we had some really powerful prep sessions, or just getting ready for trial with Miss Brown and Aaron, and kind of went through the how this wreck kind of not just affected Miss Brown, but how it affected like the whole family, the family as a whole. Because Aaron's an adult. I mean, he was in his 30s. When this wreck happened, he was living in Houston, and so it had a severe effect on him. And Miss Brown, before this wreck, was a very independent woman. Even despite her back injury and stuff that she had gone through before, she was extremely independent, and a person that felt a purpose, the need to like contribute to society. She was not one of these people that is like has ever been a drain on society. She always feels like the need to like help somebody somewhere. And that's where the volunteering came in, because that's something she could do. She couldn't do her RN work anymore, but she could still help people. And so when it came to how to present this case, because it was essentially an admitted liability case, they didn't like file like stipulation of liability, and they didn't file a motion to prevent us from talking about the facts of the wreck itself because they thought their strongest fact, and their strongest fact probably was the fact that it was a little tap. That's what they said. It was a little tap. No property damage. It wasn't a fender bender. It was a no fender bender. So that was their strongest fact, liability fact. And in fact, Courtney filed a motion to limit to try to keep the stuff out, and the judge denied it and it came in. So they hammered on the no, the no property damage pretty hard throughout trial, through depositions and all that kind of stuff. And the fact of the matter is, I think the top offer was just over $25,000 pre-trial.
Wow.
Official offer. They talked about offering policy limits, but they never really actually did. Okay. And so Courtney did this workup with Cindy and Miss and the coworker. We sat with Miss Brown a bunch because she's the type of person that's just, she'll stop by just to say hey. And she always has been, even like, because I represented some of her family members on domestic cases and all kinds of stuff in the roughly 16 years, 17 years that I've known the family. So and she'd stop by and drop a gift off for the office staff and stuff like that. So she's a wonderful human being.
Wow. And also, that's another thing that's fantastic is when you have a client that you really click with and care about, and they, appreciate you. Sometimes we feel, I know we've all been there. Sometimes we feel like you're doing the work and you're slogging, and the client isn't quite in lockstep with you, and that can be very difficult because of all the fighting we do. The last person we need against us, or at least in any sort of friction, is the client. So that's fantastic. So as we're talking about walking these before and after witnesses through their testimony, do you use, I guess, what we would traditionally call leading questions? Like, do you prompt them to these specific stories rather than saying, how is Miss Brown different? That kind of a thing. Is that how you kind of make sure you're keeping stuff tight and on the line and moving, as Courtney was saying?
Yeah, so I'm sorry, you go ahead, Courtney. You did the prep and you did the direct examination for each one of these witnesses.
So generally speaking, my preferred method is to toss them a big wide open question. If they flounder on the big wide open question, then I will say, well, tell us about going to the movies. It's not exactly leading, but it does prompt them. Like, oh yeah, there was that story where I was going to tell that story, right?
Right.
And usually if you can do that for them, off they'll go.
Mm-hmm. Right. So then how do you keep them off, keep them from going off for 10 minutes or 5 minutes? Or I'm asking for a friend, obviously.
I can tell you.
Witnesses who don't talk at all, right? And no matter how much time you spend with them, I had one whole group of witnesses who, when we were, just talking, they would share everything, and you put them on the stand and they're like, and they choke. And then other people, it's very hard. And then they get on the stand and they speak for like an hour and you're like, oh my God, so what's your strategy? How do you do it? How'd you get them on and off, but also let them tell what they needed to tell?
Yeah, I mean, at least in this case, I didn't feel like we had any big talkers. Like nobody needed the hook, Yeah. But I don't generally notice that too much with before and afters. I feel like all my before and afters are always terrified, and especially like in federal court, because it's so imposing. You put them up there and they get the microphone and the big judge up on high and everything, and they shrink, they shrivel, So I have not had the experience of like a runaway before and after witness, but
good. I hope that you do not. Yeah. Okay. Well, that's good. Okay. So prompts everyone, let them, you can do maybe a how are they different type question. And then if they're struggling a bit, make sure you have those pieces that you want them to talk about to help prompt them into giving those stories that are specific. And that's important, if you go to the Witness Prep College or, various other colleges talk about it. You want to have it specific enough that your defense is not going to file a motion to exclude several before and after witnesses for cumulative or all, evidence and all that kind of stuff. We tend to have judges get wonky sometimes when they're like, wait, you have 6 people testifying. What are they going to testify to? And if you can give them very specifics, these stories, that's going to be a really big help. So, all right. What else? How did you guys decide your order of proof? Like what witnesses went where and why? And tell me about that.
Yeah, so order of proof, especially on a car wreck case, we always try to start with the defendant. That's always the first out of the gate. And if it's a contested liability or if it's not a contested liability, where you got to provide a different type of theme of the case when you got a little old lady that rear ends another little old lady that causes no property damage. It can't be about the violation of failure to look, like the actual traffic violation, because everybody's playing on their cell phone these days, and they all relate more with the person that's doing the rear ending than the people that are getting the rear ended. And so what we tried to bring out with her is, hey, yeah, she violated the law that of the out there, and she and she didn't want to be responsible for her violation of the law, even though she was admitted she violated the law. So and that's kind of how we wanted to frame up the case, and that's how we started the case off.
Okay. And was this a little old lady who hit your little old lady, or?
Yeah.
Okay. So that is what you were dealing with in this case. Okay.
Yeah,
So tell us a little bit about how you walked her through that without, presumably alienating her, beating up on her too much.
Yeah, and I mean, we had an OSI because she had done this about 6 months before.
Oh, that's helpful.
But both of them were no big deal. It's no big deal. We just wasn't paying attention a little bit.
Cute little old lady just crashing around.
So, we got the facts of the case out quickly because we knew that there wasn't going to be a lot of toleration by the judge of dwelling on the rules of the road, and you violated these, and you did this, and you did this. So that had to go quick and smooth, and luckily it did. And then we went to well, you don't believe Miss Brown is injured, do you? And you don't, and stuff like, and you do, what basis do you have? And of course she didn't have any basis, and we kind of went through some of the symptoms, some of the treatment that she went through, that they were saying that the defense's position was, that's not related to the wreck. And we just kind of stepped it through some of those quickly, where what proof do you have that she's not suffering? She didn't suffer an aggravation of her hernia or, a bulging disc and degenerative disc disease, that was caused by this wreck. What proof do you have? And she was pretty easy. She was pretty agreeable and fairly honest about what she'd say, I don't know, that's, it's not for me to answer, something like that. So we didn't dwell on that stuff really too much. And
did you get any pushback from defense or the judge about hey, that's a question for an expert? Oh, it's not her, anything like that? Nothing?
No, there really weren't a ton of objections, and we moved through that stuff so quick. And that it was, if there would have been an objection to something like that, it probably wouldn't have come off real well. So just like that, they didn't want to either answer the questions about why we're all here, and or answer questions for me. So after that, after we finished what they of course reserved, we put up our Dr. Wolfson, the video deposition, which I don't think the wreck was more than 20 or 30 minutes. The whole deposition was like an hour, cross and everything. Dr. Wolfson did a phenomenal job of explaining the difference between degenerative disc disease and a bulging or herniated disc. the difference between an asymptomatic bulging disc that is smaller and a symptomatic one that is bigger, and how that occurs, why that can occur from such a light impact. Because when somebody's in their upper 60s, like everybody has degenerative disc disease. And all that does is mean that disc that's between those bones is more susceptible to further injury or injury. A degenerative disc disease is an injury, but she actually had a specific injury to one level. And then she had a 3-level disc bulge after the wreck. And we luckily had some MRIs from 2014 when this wreck was in 2017, and then some from 2017. So we could put one set up to another set and show the difference between the bulges. You don't have that a lot. Yeah. But when you have pre-existing lumbar issues, you generally do have some of that stuff. And you could actually physically see the difference. And then we can put the radiologist report of the first MRI next to the second one, where they compared the 2017 MRI to the 2014 MRI and showed the difference between the two, and that the radiologist that's just reading scans can say that there is a difference between the two MRIs. So I think that helped significantly, and we tried to hammer that with not only our expert but their expert. And Courtney did the direct examination of Dr. Wilson. She took his deposition. She prepared, which I think Dr. Wilson kind of helped prepare her more than her, because he's really phenomenal.
It's good when you have a good expert or treater that they're teaching you what to ask them to get the best testimony out of them. That's
oh yeah, it was wonderful, because I asked him something. I was like, hey, I want to ask it this way. And he was like, don't ask it that way.
Don't ask it like that. Awesome.
Okay.
So was he naturally I know, Courtney, earlier you mentioned that he was willing to meet with you, willing to talk with you. Was it something you had to coax from him, or is he just kind of a good guy like that? It's hard. You just don't run across that very often. I find I'm fighting with treaters all the time. They're like, I love your client, that's a wonderful patient, but you want me to testify? No, sorry, don't do that.
So Wolfson's kind of a unique duck. He is not Southern. He's from somewhere up north. And he began his medical career doing DME, IME type stuff with Social Security Administration and workers' comp and stuff like that. So he has some familiarity with the legal process.
Okay.
So I think that made him not shy, in the way that some doctors are with lawyers. Mm-hmm. He was as soon as I walked into his office, he was like, all right, what are they going to say? What are they going to throw at me? Because he's done this before.
Yeah. Okay. Awesome. Well, that's, I shouldn't say lucky. It's not the right word, but that's fortunate that it was who she ended up treating with. Okay. So we've got Defendant, we've got Dr. Wolfson. Who else after that? Was this a really short trial? Sorry, I'm kind of all over the place, because it doesn't sound like there were tons of witnesses.
We put on our whole case in a day.
Yeah, probably less than a day. I mean, we started picking a jury at 9:00 on Tuesday morning, and we gave it to the jury before lunch on Wednesday. Wow. So yeah, I don't think we spent more than 20 or 30 minutes with any witness for our part of any examination. Maybe the cross-examination of
and Tynes is longer, yes.
Yeah, that might have been 40 minutes, 45. But we made it a purpose to be fast with everything. And so after Dr. Wolfson, we called
Cindy McGee. And then Jamie Lincoln, and then Aaron.
Yeah, and Aaron was a pretty powerful witness. He testified about that. Once he saw how his mom was after the wreck in the summer of 2017, he moved home. He moved from Houston back to Goshen, Mississippi to help take care of her. And he talked about how that the wreck affected not just Miss Brown but the whole family. How it affected Miss Brown's relationship with her grandkids. You know, that Miss Brown went from somebody that was volunteering and helping people to do household stuff to needing volunteers when he would go out of town because he worked offshore to do those household chores. And really, I mean, just a powerful witness.
I'm blown away. That's fantastic. I mean, a perfect order of proof. And you know what? Wham, bam, thank you, ma'am. Take the facts and decide what you will. How did you ask for damages and how did you calculate that and whatnot?
Yeah, so we asked for 2.5 million. There was 350-ish thousand in economics, and they came back with 931,000.
What was your 2.5 based on? How did you ask for it? Did you do a per diem or a like value of a painting or whatever?
I did not do a per diem in this one. You know, I did the man in the black hat, you know, closing. So
Know that one. What is that?
yeah, it's you know, I'll put a picture of a man in a like black silhouette with a suit on and stuff on the PowerPoint, and I said, I want to take you back to January the 26th of 2017, the night of January the 26th, 2017. There's a knock on Miss Brown's door. She answers the door, and there's a gentleman with a briefcase. And he says, Miss Brown, I got this briefcase, and it's got $2.5 million in it, and it's yours. And she says, I don't really understand. I mean, what is this for? And he goes, well, it does come with some strings, and please understand that I can't change the future. I'm just telling you what the future holds. But tomorrow, you're going to have a really bad back injury. And you're going to need surgery. You're going to do everything you can to avoid surgery. You're going to spend 3 years in physical therapy and chiropractic care to try to avoid that surgery, but eventually you're going to have surgery again. And she said, well, I don't want your money. She tries to close the door, and he stops the door and he goes, ma'am, I understand you don't want this to happen, but it's going to happen. And I'm just here to negotiate a price for what you're getting ready to go through and what's going to be taken from you. And she says, I've had this surgery. I don't want this surgery again. And she closes the door, and he hollers through the door, I'm just going to leave this here for you out here. And it's yours. And she says, no, I don't want it. You take it. And he walks away, and he leaves that briefcase there. And, you know, that might be enough, and that might not be enough for y'all to determine what's been taken from her and what she's gone through. You get to determine that. But that's the only way I know how to explain to you what the fair market value of reasonable compensation is for what's been taken from
her. I hadn't heard that one before. Thank you so much for sharing that. I'm always looking for different ways, and I know everyone listening as well to, you know, make that ask. So that's really cool. Thank you. All right, let's see. What else? We've got about 10 minutes left. Let me think. Oh, did you do any focus groups?
Nope.
All right,
Yeah.
we're like, let's just put it on and see what. Oh, let's talk then about, okay, so how did you? I mean, there are some obvious themes, obvious issues kind of with this case. We already know, you know, low property damage, older plaintiff, individual defendant. All of these things are just like regular challenges that we all know about. So how did you know that presenting this whole thing and then asking for quite a large amount in damages was not going to scare off the average person?
You know, the first big federal trial that I ever had, my wife, who's also a lawyer, she said, "Hey, babe, go big or go home."
Mm.
And kind of that's kind of how I've taken that to heart. And I do, when it comes to asking a jury, telling them, what my feeling is of what this is worth, I just feel like it's got to be something that I feel in my gut that is right. That is yeah, I can't second guess myself, so I have to believe that that's right in my heart, and that's kind of the way I go about things. And if it's wrong and they punish me for it, it's still what I felt, and I feel like you got to be honest with them. If you go below that or above that by trying to satisfy, the 12 people in the box, they will see it, they will feel it, and they will punish you for not being honest. So it's just something that I feel.
Yeah, that's great advice. Okay. How did you decide? Well, I guess this was close to a no offer case when you're at about $25,000. And so was that kind of your impetus for choosing to go to trial? You're like, listen, we have to, basically.
Our client was not taking that $25,000.
Yeah.
She was ready to go to trial.
I mean, and at the end of the day, say you get zero, it's like, okay, but she still was going to end up with zero-ish.
Yeah, I mean, the Medicare liens were way above 25,000. So
yeah, they would have taken it all from her. All right. And how did she feel about going? I mean, it sounds like she was fired up and ready to go to trial. Did she feel like that because of she was kind of offended by their not taking responsibility? Did she want to tell her story? What was her motivation?
Oh, she's offended. She's very offended.
Mm-hmm.
I think every time I spoke to her, she would say, "I don't understand." She ran into me. Like, I can't tell you how many times I heard that.
Yeah.
She was flabbergasted that the insurance company wouldn't simply pay for her damages because she thought like that's how it was supposed to work.
Yeah. So it would be lovely if it did. What was the policy? Like, what could they have gotten away with potentially if they offered?
100.
Interesting. Okay, then are they appealing? Have they paid? What's the status of the verdict?
So we've gotten through post-trial motions. They filed a post-trial motion. They contacted some of the jurors, that night, and they got an affidavit from one of them saying that what the jurors did was add, like they each wrote down the damage award for economic and non-economic damages and put them in a hat, drew them out, or I don't know if they put them, but they were.
It was submitted anonymously.
Yeah, anonymously. They added them up and divided it by 12, and that's how they came up with the damage award according to this affidavit, which that's a quotient verdict. And there is some case law that's not real great about quotient verdicts in Mississippi. So they, they filed the normal type of post-trial motion where like there's no proof that that this was related to that, and that she had a change in her life, and they cited all their good evidence and wanted the judge to discredit all the evidence that supported the verdict. That's we get those every single time we get a verdict. So, but the other one scared me. So when I read the email to the judge the day after the verdict, we researched that heavily, and luckily, Mississippi says that the deliberation process of a jury is basically sacred, and that a juror can't, by later testifying or providing an affidavit impeach their own verdict, the jury's verdict, and there's plenty of case law that strikes the affidavits when people try to do this. There's I think there's like 8 cases in Mississippi that, and Courtney is the queen in writing, so she we mostly write our stuff together, but she does the most of the heavy lifting. I did the motion to strike. She did the response to the motion for JNOV. And a couple of weeks ago, we got the judge denied their JNOV, granted our motion to strike. I imagine, that's the status now. So,
okay. Well, we'll see what ends up happening. All right. Well, I guess so. If you're not allowed to talk to the jurors after, I mean, was there some concern that the defense had done that, or is it's not like prohibited because you weren't in federal court, so it's just kind of frowned upon? And
yeah, I think it's Rule 601 of the Mississippi Rules of Evidence that talk about the process that you're supposed to use. I think it's 601. It's in the 600s of the Mississippi Rules of Evidence, which the process you're supposed to use on a post-trial investigation is if there's a belief or something that the jury considered something improper, like they had an outside influence, you file a motion with the court and ask the court to do investigation. But the few cases that actually address like head on that regarding a quotient verdict is they say, well, it's improper and that kind of stuff, that you're still not allowed to, that's not outside influence. That's not something that the jurors considering outside evidence or things. So it shouldn't be reversed or a new trial granted based on that. So,
and the fact that defense talked to them at all, did the judge sanction them or warn them that they weren't supposed to do that?
Yeah, so I mean, we cited that Rule 601 in the footnote about how they're supposed to, how they're supposed to go about that, and that they didn't follow that process. But the defense counsel emailed the next day asking the judge. He emailed the judge asking the judge to go through the jury room to find any evidence of the improper quotient verdict. So.
Interesting. Yeah. All right. Well, any last words before we wrap it up?
Thanks for having us.
Yeah, we just appreciate you having us. Good luck to everybody out there. And a broken clock's right twice a day.
Yeah. Well, thank you both for being here. I appreciate it. Thank you for making time in your schedule to pre-record this episode with me. And thank you to all of you who are listening on any of the various platforms that the KTI Fridays with Keenan's Cutting Edge podcast airs. If you like today's episode, please make sure to click that thumbs up button to feed the YouTube algorithm. And don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we have Amy Gibson back, one of our very regular guests on the podcast and a stalwart in the Keenan Trial Institute. And this time she's going to be talking with us about a new college program at the beach. Now, this must be all hush hush because it's the first time I'm hearing about it. The episode will be live, so it'll be Friday at the usual time. And I look forward to learning about this new college with all of you. Have a wonderful weekend, and I will see you next time.